Hello friends, how are you? Today I am going to discuss an important perspective of Prevention of Corruption Act and Section 3 of Prevention of Money Laundering Act. Recently, Honorable Supreme Court, in its judgment, had clarified that if the scheduled offence is not made out, in that scenario, the proceeding under Section 3 of the Prevention of Money Laundering Act could not be allowed to be continued. Friends, we have to understand the entire position in terms of factual score, in terms of legal position, and apart from that, we have to consider the legal perspective that is inter alia considered by Honorable Supreme Court as well while pronouncing the judgment, so that we could reach at the appropriate conclusion, so that if we are having the same issue, same problem, so that we could easily get a solution to the same. My humble submission to all of you is that please maintain a copy and pen, so that whatever I am going to narrate you could be maintained by you in a scripted form, so that you could easily analyze the problem, and while analyzing the same, you could work on it and could easily got a solution on the same. In this case, a case under Section 13 subclause 1 subclause E of the Prevention of Corruption Act had been registered against the accused person. They faced a trial, and ultimately the concerned trial court found that the prosecution totally failed to prove the offence beyond the reasonable doubt. Ultimately, they have been acquitted. In the meanwhile, they also filed a discharge petition in the concerned court having an authority for the trial under the Prevention of Money Laundering Act. The application had been allowed. Being agreed from the same, the concerned state had filed a revision petition before the Honorable High Court on the ground that the concerned trial court is totally erroneous in its approach. The High Court, while considering all the contention of the state, succeeded the revision petition and ultimately directed the trial court to frame the charge again. In the meanwhile, the concerned accused person approached to the Honorable Supreme Court, and whatever contention had been raised by them through counsel is not only accepted, but also their appeal had been allowed by the court while exercising the jurisdiction. First, we have to examine the contention, then we will examine the observation of the court as well. They submitted that the issue involved in the present case has already considered by the Honorable Supreme Court in Vijay Chaudhary versus Union of India, in which it is held that the offence under Section 3 of the Prevention of Money Laundering Act depends on the illegal gain of the property as a result of criminal activity relating to a scheduled offence. It is concerning the process or activity connected with such property which constitute the offence of the money laundering. The authorities under the Act of 2002 cannot prosecute any person on the basis of assumption that a scheduled offence has been committed unless it is registered in the due course. If the person is discharged or acquitted from the charge of the scheduled offence, in that condition he could not be prosecuted under Section 3 of the Prevention of Money Laundering Act. The court observed that the concerned public prosecutor appearing on the behalf of the state is fairly admitting the said legal position, and looking to the fact and circumstances, the court allowed the appeal and inter alia found that they are not guilty. So we could easily draw a conclusion that if the offence is committed, that is a scheduled offence, and inter alia the concerned accused persons had been discharged or acquitted from the concerned court, in that scenario they could not be prosecuted under Section 3 of the Prevention of Money Laundering Act. So don't be disappointed if you are having the same trouble. Just go with this citation and definitely you will be acquitted or discharged from the concerned offence. Friends, if you like this video, kindly share it. See you next time. Till then, Jai Hind, Jai Bharat.